what are some common things that people do that they ought never, never do in arguing a case or a motion to the judge? And I've seen hundreds and hundreds of lawyers arguing over the years on my cases, on other cases while I'm waiting in court to make arguments. Here are a couple of the classic mistakes that people make. Number one, they interrupt the judge. Never, ever interrupt the judge. I don't care what argument you have planned. When the judge asks a question or makes a point, you stop, you freeze, you listen intently, and you focus on what the judge must be thinking or asking. What is bothering this judge? What is of interest to this judge? In my case, why are they asking this question or making this point? You don't interrupt or talk over the judge. I've seen it done time and time again. Lawyers can't seem to help themselves. They get going, they've got a presentation. Nothing could be worse. Second error that's made. Lawyers go in with a plan, and that's the right thing to do. You need to go in with a planned presentation, key points that you're going to make that drive to a particular conclusion. The judge interrupts the lawyer and asks about a point that the lawyer intends to handle later on. And I've seen many, many lawyers say, Your Honor, I'll be getting to that. Your Honor, we will get there. I'm going to cover that. Absolutely wrong. When the judge asks that question or leads you to that point, you must jump immediately to that point and talk about that point. That's where you have to go, even if you come back to other things in your argument. Even if it isn't organized the way you want, you go where the judge is interested in the case. Third thing that I've seen many, many lawyers make the mistake over the years. Judge asks a question or makes a point. It's a hard question or a point that they're uncomfortable with. I saw a lawyer one time come back to a bench where there were a group of us sitting, because it was a multi-party case, and whispered to the others, Phew, I avoided that question. Absolutely the wrong thing to do. The fact that the judge is asking the hard question, the fact that it's hard for your case, is exactly why you don't want to avoid it, because this is your chance to influence a judge. You've written your brief. The other side's written their brief. If you're going to turn the judge at all, if he's leaning against you, or if you're going to confirm him if he's leaning towards you, you've got to know what's on the judge's mind. So there's nothing wrong with saying to a judge, well, Your Honor, that's the central question, or that's a really hard question for our side. And I can see why you would say that. And that's a point that goes this way. And here's the answer to it, or here's the best answer that we have to it, or it's one factor and there are these other factors. And so, yes, while that one goes over here on the scale of justice, Your Honor, I see that. Over here, we've got these factors that you've got to weigh against it. And that leads to the fourth point that I would make, is candor. Complete candor with the judge. If you don't believe it yourself, you can't convincingly argue it. When you stand up, you better believe every single point that you're going to make. When I'm arguing, I will say we. I may represent a corporate client. I may represent an individual. I don't say we because I'm trying to mouth that. I say we because by the time I have stepped up to argue it, I've adopted it. I believe it. So I say, we did this, or we did that. Or I can say my client. But the point is that I'm completely aligned with my view that I'm arguing. If you can't be completely persuaded yourself, you're not going to persuade a judge. They recognize a phony, and they recognize an argument that you don't have your heart in. So when I get up and argue, it's going to be passionate because I'm passionate about it, because I believe it's the right argument. And if it isn't the right argument, I throw it out and find another. And if there isn't another, and if you don't have an argument that you can make, now's the time you got to sit down with your client. This isn't about winning the impossible case every time. This is about figuring out which points, which arguments, which cases to present, and when you have to give the hard lesson to the client and say, I'm sorry, the judge is never going to get there. This case is going to control. So we're now talking about damages or something else rather than liability, because we can't argue that, and we're not going to lose our credibility by arguing it. So you got to believe it by the time that you get up. And I know that in moot court, in law school, people argue both sides of an issue, and that's fine. It's very good training. Those are by and large legal issues on which there are two sides, often legal political issues, issues of common interest today. And there are often at least two sides to those, maybe more. You know, the old joke, you show me a one-armed lawyer, you know, you got on the one hand, on the other hand. You know. All right, so there may be a number of perspectives or views that you can argue on a legal issue that might go to the U.S. Supreme Court or the Supreme Court of the state. Very different when you get to the facts of the case. You've got to give facts that go against you. You've got to admit things that you're going to look like an idiot trying to persuade the judge. Keep your currency for things that are in dispute.